Hello, I'm Rafe Foreman, and today I'm with Chris Stoy. We are part of the Warriors for Justice team, and we want to talk to you about what happens once you become a client of Hutchison and Stoy. And this applies across the board, no matter what kind of case you have, whether it's personal injury, employment, criminal, all kinds of cases. I want to first start off, Chris, talking about social media.
Yep.
Oh my gosh. More people are convicted, more people lose their cases because of posts they put on social media than I can account for in this video.
I've lost a couple of trials because of posts on social media that were taken out of context and put before a jury, and it killed the case.
We're not telling you to delete anything that's on your social media, because that would be spoliation and it could be a bad result for us at trial. However, we are telling you, asking emphatically for you to stop posting things on social media after you hire us, especially on an injury claim, well, on any kind of claim. I think it goes across the board. Here's the problem. I don't usually post things on my Facebook, but somebody else will take a picture of me and post it on it and tag me, and it gets posted. You got to turn that feature off.
Yeah.
If you're claiming that you have, and if you rightfully so have a serious injury, not a good thing for them to have a picture of you at the bowling alley, because they didn't see that you walked in on crutches or with a walker or on assistance. All they see is you sitting here at the birthday party smiling among all your friends. They don't know that you're not bowling. You just went out there for somebody's birthday. It's out of context. You gotta be careful, because that's going to come back to haunt you. I promise you, every single case that's filed at the courthouse, somebody on the opposite side is checking your social media.
Yeah, and let me give an example of one where my client wasn't even tagged, but her husband had a public Facebook account, so every post that he did was public. So they'll search not only you, but your loved one's Facebook accounts looking for pictures, and if they're public pictures, they're going to find them. On this particular one, the accident happened like December 17th, and the client had a ski trip planned for like 9 months, right? And she had a pretty significant injury that ultimately needed shoulder surgery. But they had paid for this trip, it was prepaid, they had planned on it, big social family gathering, and she was bound and determined that she was going to go. I don't fault her for that. I think I would have done the same thing. She rides the gondola up to the top of the mountain with her husband, and he takes a photo saying about to go down another run. She doesn't even go down the run. She rides the gondola back down, and she testifies at trial that she did not snowboard or anything like that. But because that post was taken, and the defense lawyer was very tactical about it, he let the jury infer that she probably was snowboarding there and that caused her injuries, when in fact she didn't snowboard. I believe, and to God, that she didn't snowboard that day, but it just, the mere impropriety was enough for the jury to say, we just aren't going to give her that surgery, and it killed the case. So it's the little things, and it's not even just your social media, it's your loved one's social media. So just even be cognizant about not getting in pictures with other people.
I don't know how you feel about it, Chris, but we invest our time, our money, our effort, and to be hijacked by a social media account is so disturbing.
Well, and it's what it hurts more sometimes is to see my client struggle with the frustration of that picture, because she knew, like, man, this is not good evidence, and to see them realize that, well, and in that case, lose the case because of that post, it hurts to watch that.
Yeah, we don't want you to lose your case, period. We certainly don't want you to lose your case because of some post that somebody inadvertently put on Facebook or social media.
That some defense lawyer takes out of context and makes a mountain out of a molehill.
So be careful. We're telling you this because we think it's in your best interest.
Yeah, please. The next thing we like our clients to do is keep a diary or a journal. This is important to me because Rafe will expound more on this, but it's the little things that win us our trials. It's little things, the little details that make your story. And if you'll just, take a 8.5 by 11 sheet of paper, go by Walgreens or wherever your pharmacy is, and get maybe a little Mead notepad, and just write maybe 3 or 4 sentences 2 to 3 times a week about something that you struggled with, like was planning on going to play tennis with Tammy and I couldn't go because my knee was hurting, or wanted to go to son's football game but my back just flared up so I stayed at home. And then write down the associated feeling that you have, because feelings are everything, right? It's one thing to have the fact that you missed it. It's another thing to associate it with a feeling, like feeling depressed or obviously sad. Maybe even include reactions that your family had based on the things that you could or could not do. Now, why I ask you to do that is because in the event that you are deposed later on, if we can't get the case resolved pre-suit, it's going to be maybe a year and a half since the injury and since all that struggle, and you're going to kind of have forgotten about some of all of this. It helps to have that diary to just go back and be like, oh my gosh, yes, I forgot. I forgot I was feeling horrible then, and I forgot that I was going to go and do that. And then that way you can testify about how the wreck affected you, and we as trial lawyers can use that to expound on your story. And that's where you really have some talents, is taking those little bitty few sentences here and there and making it a better story, right, to tell to the jury. Talk more about that and how that helps.
Well, I agree with everything, Chris, that you just said. I feel like that we overlook so much of the story and the richness of our life because we don't think it's good enough and nobody would want to hear about it. Let me just say to you, you're good enough, your story's good enough, and you're the world's leading expert on yourself. There's nobody that knows more about you than you, and so we want you to put those things in a journal. I want you to also put the good things. Defense lawyers act like I got hurt and I can do nothing for the rest of my life. That's not reality. It is for some, but most cases, you have good days, you have bad days. I don't mind if your diary says it's a good day today.
Yeah.
And then that shows the contrast of what a bad day looks like. We want you to be accurate and honest, but more importantly, 2 years from now, when you're sitting in front of a jury, can you really remember how you were feeling at the tennis court when you had to quit playing because your back flared up? I don't know. Maybe you were suffering from some depression post-injury, and then things got better for a while. Then you had a flashback, or you had a triggering event. You heard something on the TV news or the radio or whatever, and it took you back to that moment, and then you had to go back to counseling again. That's real life. That's how people really interact. And
that's so true.
We'd like for you to journal that, mainly so that you can remember it, because we're not there. We don't know what's going on in your life, and we need for you to write those things down so that we can use them to tell the jury your story.
I love what you said about sharing the good days as well, because we want to submit our client to the jury and portray that they're trying to get better and that they are getting better, and life hasn't ended, right? I've read so many great books by great trial lawyers and listened to podcasts where they say, like, you want your client to be having living his best life, doing the best things that he can, showing that he's trying to prevail, trying to move on from this, and then let the jury validate what's happened to him, the bad things.
That's right. I heard a saying, and I don't know why what you said made me think of it, but do you know what's more powerful than a client crying on the stand?
So, I don't know. It makes me chill just thinking about it.
A client trying not to.
Oh, yeah, so true. Absolutely.
Because we want real. That's what we want. We don't want fake, pretentious, made up, rehearsed acting. We just want real. So whatever's really going on with you, that's what we want, and that's what we can do best to represent you. And that's what your lawyer, no matter who it is, can do best to represent you.
Absolutely. All right, so those are kind of our things on social media and diaries, but I want to talk about treatment. So some of you have come to us and you're already done treating, and so we're just processing your claim and filing suit if need be. Others are going through the treatment process because the wreck happened not too long ago. It is imperative that you go to your treatment. Why? Because it shows that you're trying to get better, okay? And it's so hard to convince a jury that you had pain and suffering and mental anguish from a wreck when you didn't go seek treatment for that. It kills a case. And it makes you better. I mean, there's a reason you go to a chiropractor, a reason you go to an orthopedic doctor. And I understand that you're having issues about getting to the doctor. We send Uber Medical out to clients when they absolutely need it. We help facilitate those medical treatments. We work with doctors that provide transportation. Use that transportation, because if you're not going to do your part of getting better, there's no way that we can seek adequate compensation for the injuries that you claim to sustain from this wreck.
That's so true. But what if the client, and I hear this all the time, it's not help, I'm not getting better, so I quit going.
Let us know. Oh my gosh, thank you for bringing that up, Rafe. So I have clients that I love because they let me know that the treatment isn't working, and then ones that I just get so frustrated with because the treatment isn't working and they don't let me know. We do our best to stay in constant contact with you, but it's like the Jerry Maguire saying, help me help you, right? Mm-hmm. If you don't tell me about it, there's nothing I can do about it. I've done this. I've worked with thousands of clients and worked them through the processes. By no means am I a doctor, but I've done this so much that I know, like, hey, well, I think that you should at least go talk to this doctor because it sounds like you've got this issue. I know where to go and what to do, and I'm happy to direct you to that, show you where to go so that you can get better, but you've got to let me know. Don't just let that boil fester, so to speak.
I've had clients ask me, they say the doctor talks to them about maximum improvement or something like that. What do you think that is, and what do we need our clients to know about that?
MMI, maximum medical improvement. That's a medical term for sure, right? So the doctor is doing his best to get you to maximum medical improvement. I mean, take an extreme example. If your leg was amputated, the maximum medical improvement is that you're walking on a prosthetic and that you're able to do certain things. Obviously, you would have much more limitations than someone who has both legs. Their maximum medical improvement would perhaps be that you're exercising and running again and doing all the things that you're supposed to be doing. But it means getting you back to as good as they can get you, because often with these wrecks, and there's plenty of science out there, these injuries are going to last a lifetime. I mean, something as small, a small wreck can cause a neck herniation or a disc bulge in the neck or spasms in the muscle. They're going to remain there forever, and you're going to continue to have flare-ups for the rest of your life. But the doctor is going to get you to as best a point as he can get you before he releases you.
Does that mean he's going to heal the plaintiff completely?
Nope. So many times, and that's why we ask for future medical, is because it's a word that I have come back to multiple times. It's flare-ups, and some doctor taught it to me a while back. It's just like what Rafe was talking. You have your good days and your bad days as you're working on recuperating from this wreck. Even moving forward, years from now, you're going to have your good days and your bad days. You're going to have your days where you wake up and you've had a flare-up because whatever you did re-aggravated that injury that you sustained from this wreck. I know this because I've been doing this for a while, and I deal with patients and clients on a day-to-day basis. And doctors know this because they've been practicing medicine for a long time. You, if you don't have that experience, don't necessarily know that. It's like me dealing with my contractors when they say, you probably ought to do this, and I have little or no experience. And I said, nah, I don't need to do that. I pay for it later. You know, they said, you should have balanced your house. I told them it'd be fine. Now we're balancing my house. Mm-hmm. Little things like that. Just trust us.
Yeah. Trust is such an important thing. It's a two-way street. We trust you. We need you to trust us so that we can best work together. And that kind of leads us into our next topic about expectations. I like to do a client inventory of expectations. What do you expect from us? Sometimes I have clients, I want you to make that guy lose his driver's license. We can't do that. That's not something that we're possibly able to do.
Not a legal remedy.
Yeah, it's not. Civil law, only can we recover the value of the loss, which is dollars. We can't make them give you a car that was just like the car that they wrecked. We can't make them, put a lien on their house.
Can't take away their home.
Yeah, and if you have unreasonable expectations, we're going to tell you right up front because we can't deliver on those. So I think it's important for us to set out the expectations that you have and the expectations we have. The expectations we have are that you will listen to us, you will follow our instructions and our recommendations, you will consistently carry through with your treatment, you will report to us if the treatment's not working so that we can explore other options, and you will let us know when you have completed treatment. And then there's a whole lot of other expectations we have towards trial, which and depositions, which we're going to cover in another segment called trial preparation. But up to the point of trial, those are our expectations. What did I leave out?
God, I'd say don't disappear, please. I have clients who will disappear, and they disappear like intermittently. They'll be gone forever, and then they come back, and they'll be gone forever and come back. I've got one right now I'm thinking of. His statute of limitations, meaning the deadline to file the lawsuit's coming up, and we've got a really good offer on the case. We could settle the case, but he won't talk to me. To protect my malpractice insurance, I'm going to have to file suit on this case, which means my fees and expenses are going to go up, just to make sure that we don't lose this case because he's disappeared. And I told him from the get-go, you have a duty to cooperate, and you agreed to this when you signed our contract. You have a duty to cooperate, but I've got to make decisions. I've got to protect myself so you don't come back later and say, well, you let my statute of limitations pass. So stay in touch. Also, though, see, in this case, he was staying in touch and then disappeared recently. If you disappear early on, we reserve the right to stop representing you in this case, and then you're responsible and on the hook for the medical bills and the expenses and all that. So if you disappear, there are repercussions for that.
Yeah, and people disappear, Chris, not only before suit, they disappear after suit. I have a case right now where if we can't find you, we have deadlines that you may not know about. For example, we have to answer discovery on time, we have to send out discovery, we have to file affidavits with our medical records, and if we can't find you and get the answers to this discovery, we can't file them. And so please stay in contact with us. And I know, here's the problem, every time you call, you feel like you're bothering us. Every time you call, you hear same old thing, nothing's happening yet. But be patient. This is a marathon. It's not a sprint.
Yeah, that's a good segue into, I guess, the next topic, and that's communication with the law firm and I guess navigating that communication. You want to take that a little bit?
Yeah. Talking to Chris, talking to Susan Hutchison, talking to myself, talking to Rob, Kim, or any of our paralegals or legal assistants is talking to the firm. If my paralegal tells you something, that's number one, probably I told her to tell you something, or she knows what to tell you. And let me let you in on a little truth. The paralegal probably knows the answer to your question off the top of her head. I may have to go look it up because I'm juggling a lot of balls. I won't speak for Chris and Susan, but I have to look it up. I have to make sure that what I'm telling you is accurate. The paralegal may know off the top of her head. However, she may need to talk to me about a nuance about it and get my input before she gives you that answer. So please, just be patient, understand that she has rules and obligations she has to follow. I have rules and obligations I have to follow. But talking to anybody in our firm is keeping in communication with our firm. You don't have to talk to me every time, but you can talk to our staff and our legal assistants. That's what we have them for, is to help you feel connected to the firm.
Yeah, we created a system and it works. And let me give you an example. So at the end or the beginning of the day, I will sit down with case managers and paralegals, and they will bring me 10 issues minimum usually that need addressing, like different client issues that I can go through pretty quickly, as opposed to them coming in and out all day, every day. They sit down with those 10. So imagine that you are a client who calls and it's something very simple that that the case manager can take in that information, like maybe this doctor isn't working and you'd like to go see someone else. Something that we commonly see with our clients. Imagine that you're insistent that you talk to me. Well, imagine that I'm in trial for 3 days, and then after that I've got to go out of town for a continuing education course, and that you're still insistent that you talk to me and I'm working 16 hours a day. Why not just go ahead and give that issue to the case manager or the paralegal so she can come sit down with me in that time slot that I make for her, and we can go over it when we go over those 10 things. Because that at that point I'm like, oh, simple solution. Send Mrs. X over to Dr. Y, because it sounds like she's got adhesive capsulitis and needs that remedied, and that doctor's an expert in that. But because you're insistent on talking to me, and I'm putting in the 16, 17-hour days, and not that I won't call people, but because like if I'm in trial, I'm obviously not allowed to pick up the phone and start calling people, and I may not get done till 10 p.m. Your case doesn't move. So use the system that we created. We created it for a reason, and I created it for your benefit. I mean, absolutely.
While we're in trial, if we were in your trial, you would want us to devote 100% of our effort and attention to your case. Would you please allow us the opportunity to do that for our other clients? When we're in trial for them, we really have to focus on their case. Or when we're in deposition or mediation or anything that's requiring our appearance, we will get to your answer. But I agree with Chris. Please, that's why we have competent staff. That's why we've trained them. That's why they're there. They know the answer. They'll pass along the message, and we'll communicate when we get out of trial, when we get out of mediation or deposition.
I know there's that age-old idiom that the squeaky wheel gets the grease. And you know what? I'll confess, I'm kind of that person as well. But there's a point when the squeaky wheel just gets taken off the axle and tossed to the side. And by no means do I'm saying that we're just going to get rid of the clients, but like if everything is a major issue, how am I ever supposed to determine what actually is a major issue for you?
That's right. It's the cried wolf too many times or something like that. I want to say
we love our clients.
We do love you, and we want you. We're doing this video to teach you how to navigate through our firm. I am overwhelmed with emails. I'll just tell you, emails overwhelm me. We have a system where I can send you, if you will give me permission, a note on your cell phone that says
via text.
I'm available. I would like to talk to you now. Or when would you be available for me to call? I look at my texts because they rattle in my phone and I have it on me at all times. I look at my emails when I'm not in court, when I'm not on an emergency, when I'm not responding to something. And so if you will give us the opportunity to communicate via that text function, you'll be more satisfied.
Yeah, absolutely. And client satisfaction is our ultimate goal. This is a business of referrals, and we rely on that. And we want to make sure that we're taking care of our clients. But, follow the procedures, and by all means, like Rafe said, and I truly believe it, when it comes your time where I have to give full devotion to your case for a deposition prep or a deposition or a trial, I'm going to be devoting that time to you, because you purchased that as hiring me as your lawyer, and you deserve that. And I want to make sure that I'm able to do that for all my clients, you, Mrs. Jones, whoever, because that's a principle of mine that I believe in.
I will also tell you a problem that I recently encountered is that there is a function that I call you back and it says not taking phone calls right now. I don't know how to do that. I'm going to put that on my phone. I'm going to look into that. But if you turn your phone off from 8 in the morning to noon and I can't call you, I'm going to call you a couple of times and get that message, and then I'm not going to just keep calling because I don't know what your schedule is. Please use this function and let's schedule a time. If you say, are you available at 1 o'clock on Tuesday? And if I say yes, it goes on my calendar. I'm available 1 o'clock on Tuesday, and we'll have your conversation.
Yeah, that's about all I got. We look forward to the representation, and I'm passionate about making sure y'all get the right treatment. I know Rafe is too. I know our case managers and our paralegals are all going to take great care of you, and we look forward to working with you and getting you the result that you hired us to get. So thank you for this opportunity, and I'm Chris Stoy.
And I'm Rafe Foreman.
And we're the Warriors for Justice. Thanks.